government provision came in 1996 and came in the context of a political impasse in which the current ruling party, which was then in opposition, refused to accept, quite rightly, the results of a very heavily rigged election, a complete farce. And the solution that was brought about was this caretaker provision to be inserted through the 13th Amendment. Subsequently, of course, we saw the problems with the caretaker expanded and stretched beyond all realistic possibility of survival during the 2 years of the emergency in 2007 and 8. Subsequently, the Awami League, having been elected with the stamping majority, has decided that we no longer perhaps need caretakers for transition, and now that we're in power, it may be better just to stay there, and then to see if we can hand over or not hand over and get re-elected. So the 13th Amendment, but it would be obviously a very difficult issue to have directly dealt with in Parliament. It would seem transparent in terms of it being an exercise in severe democratic erosion and the refusal to accept democratic transition through a free and fair election. So the court was essentially used to fire the gun. And this 13th Amendment case, which was a kind of weird public interest case brought by some, lawyer who does public interest cases as a matter of reflex every few months or so, suddenly was fast-tracked by the Chief Justice and heard as a matter of priority over a docket of tens of thousands of cases that were not being heard. 8 or 9 amicus curiae addressed the court. The Attorney General also addressed the court. All bar one argued that in the context of Bangladesh, and given the continuing political impasse that had been seen between the two political parties, a limited caretaker provision was the only way to ensure transition. Despite that, the Chief Justice held in a 3-line order that the caretaker provision was struck down, however, that Parliament may nevertheless proceed to retain it for the next 2 elections if it saw fit. No one understood that order. It seems very peculiar directing Parliament and what it might or might not do. But even more importantly, it was literally a 2 to 3-line order with no reasons, no full text judgment. So for a government that prides itself and repeatedly states that it believes in the rule of law, instead of waiting for the full text of the judgment, the government then proceeded to develop an extraordinary document called the 15th Amendment to the Constitution, which removed the caretaker provisions and also put in place a whole host of other things, which I'll talk about towards the end, including restoring Islam as the state religion, arguing provisions that any criticism of the Constitution would amount to sedition. Rather bizarre, the word sedition, the concept of sedition, being very clearly a colonial construct being embedded in a post-independence constitutional order. The other case, which I'll speak about very briefly, because otherwise I will speak about it at great length, because I was involved in it, is the case regarding Grameen Bank and Professor Yunus, where we also saw, and I think most of you would have at least read about this in the media, that the court behaved like, I really have no words to describe how it behaved, but a very simple question was taken to them of whether a government order holding that a person should be removed from office on the basis that the government had recently discovered that he had passed the age of retirement 10 years ago and had not seen fit to issue him even a show cause notice before passing the order, whether that could be brought under challenge. Luckily, and we went to court, and luckily for Professor Yunus, or unluckily, his legal team was rather more significant than the likes of me, and we had, I guess, what we could say were the top 3 counsel available in Bangladesh, who all said, yeah, this is really a pushover. Of course, we have to go to court and get this settled, first thing tomorrow morning. We went to court, and the court began to look very stressed, in and out, and back and forth, waiting for the Attorney General to appear, and after 3 days of hearing, refused to admit the matter, refused to ask the government to justify its decision in any matter, refused to ask for a single document which would have shown that for 10 years the government had dealt with Professor Yunus as Managing Director of Grameen Bank, and at the highest level, with Prime Ministers and Finance Ministers and Governors' Central Bank meeting, and the court went on to hold that Professor Yunus